let's take a look at the reality of employment discrimination. Many things have changed for the better since the time when our nation's primary anti discrimination law, the Civil Rights Act of 1964, was enacted. We have made some progress in combating discrimination in the workplace and making equal employment opportunity a reality, but the job is by no means finished. Rooting out the contemporary manifestations of discrimination may prove even more difficult than confronting the overt exclusion and segregation characteristic of earlier years. Discrimination is inherently difficult to prove. Indeed, much of this course is devoted to explaining the methods that the courts use to decide these complex cases. One indication that discrimination still exists is found in different employment outcomes, such as higher unemployment rates, concentration in lower level jobs, and pay disparities across different races, sexes, and national origin groups. Unequal labor market outcomes need not have discrimination as their cause, but they are consistent with the presence of discrimination. A second type of evidence for the continuing reality of discrimination comes from the large numbers of discrimination cases heard by anti-discrimination or administrative agencies and the courts. The number of discrimination charges filed with the Equal Employment Opportunity Commission varies from year to year, but an average of 93,414 charges were filed each year between 2008 and 2016. Federal court cases alleging discrimination have increased substantially since the early 1990s, often numbering more than 20,000 per year. Not every case presents a valid claim. Indeed, the majority of cases do not conclude with a finding of discrimination. But despite plaintiffs' heavy burden in proving discrimination, courts and agencies decide in thousands of cases each year that discrimination has occurred. Third, studies of employment discrimination show that it's real and pervasive. For example, researchers conducted an experiment to gauge the extent of discrimination against African American job applicants. Responding to newspaper listings for entry-level jobs, the researchers sent resumes that were matched in terms of experience, education, and skills, but differed in terms of the applicant names. Applicants with white-sounding names like Kristen or Lori received 50% more callbacks for interviews than did applicants with black-sounding names like Lakeisha or Tamika, despite equal qualifications as mentioned earlier. When the researchers varied applicant credentials, high-quality candidates with African American sounding names were at least at a greater disadvantage relative to high-quality candidates with white-sounding names. Similar studies found that equally qualified applicants were much less likely to be contacted if they revealed the existence of a disability or were in their mid-60s.